In a major victory for thousands of Indian families living in the United States, a federal judge in Seattle has indefinitely blocked US President Donald Trump's executive order that sought to end birthright citizenship. This ruling has brought huge relief to Indian professionals, students, and their families who are deeply concerned about the impact this law could have on their children's future. Soon after returning to the office on January 20th, Donald Trump signed a very controversial executive order aimed at ending birthright citizenship. According to this order, children born on US soil would no longer be automatically US citizens until and unless at least one of their parents was a US citizen or a green card holder. For Indian migrants, this order was extremely worrying. A large number of Indians in the US live on temporary visas like H-1B, that is a work visa, L-1, intra-company transfer visa, H-4, dependent visa, F-1, that is a student visa. Under Trump's order, children born to parents on these visas would not be considered a US citizen. This would deny them access to key benefits, including in-state tuition rates at university, federal financial aid and scholarships, legal certainty regarding their immigration status. Now, many Indians who were expecting to be parents rushed for preterm deliveries before the February 20 deadline, fearing that their children might be born stateless under the new law. But here's a question: why did the US court stop this order? So, the US district judge issued an indefinite block on Trump's order, calling it an attempt to bypass the rule of law and play policy games with the US Constitution. He strongly criticized the move, saying the Constitution is not something the government can play games with. If the US government wants to change the grant of citizenship, it must amend the Constitution itself. Now, his ruling followed a very similar decision by another federal judge in Maryland, ensuring that Trump's order cannot be enforced while the case continues. Now, this is a big win for Indian immigrants. The ruling is a major relief for them, specifically those who have been waiting for their green card for decades. Indian professionals make up a significant portion of the H-1B workforce in the US, but due to visa backlogs, many have been waiting over 15 years for permanent residency. Without birthright citizenship, their US-born children could have been denied citizenship even though they were born in America. Families already struggling with visa delays and green card backlogs feared that their children would have to self-deport at the age of 21 if they were not eligible for any visa category. Now, with this court ruling, Indian families in the US can finally breathe a temporary sign of relief. However, the Trump administration has already filed an appeal, meaning the issue may ultimately reach the US Supreme Court. The Biden administration, though, had rejected similar attempts to change the US birthright citizenship policy, arguing that such a move violates the Constitution. However, Trump is known for his aggressive stance on immigration, and his legal team will likely keep pushing for the order to be restrained. For now, the ruling ensures that Indian families in the US do not have to worry about their children losing their right to US citizenship. However, immigration remains a very heated topic in American politics, and Indian professionals in the US must remain vigilant about their future policy change. This case is a reminder of the uncertainty faced by Indian immigrants in the US, where policies can change drastically with every new government. For Indian professionals dreaming of a stable future in America, the fight for fair immigration policy is far from over.